So the settlement communities would evolve, say, from 1938 when the legislation was first established, or enacted, sorry. They basically operated for, well, they're still operating, but the period of time I'm talking to you about right now is till about 1969. They grew to be more capable, more confident. We're dealing with industry, better jobs, better education, just basically improving their well-being. But as this happened, and not surprisingly, of course, the leadership and the community members became more aware of their capabilities and more confident in taking those issues forward. And in addition to that, they're becoming more aware of their legal relationship with the province. And in particular, I've got a slide up here, it's the Métis Population Betterment Trust. Now that trust fund was established pursuant to ministerial order under the Métis Population Betterment Act. And that trust fund provided that any resource development that occurred on settlement lands, that money would be put into a special trust fund for the betterment of the settlement Métis. There was litigation following a few years later in regards to that, because what the settlements alleged was happening is that that funding was actually going directly to the general revenue of the province. So that action was Patra. Now, before they brought this action, the settlement councils would, there's history that they were, all along they had always been consulting with and were involved with the Métis Association of Alberta, but in particular it's important that at this stage they consulted very closely with the MAA, who were also involved as a political voice for the general Métis in the province. They consulted with them and said, okay, what do we do to address this? So with their assistance, with the association's assistance, an action was brought in the name of one of the individual members of the settlement, so it was Richard Patra, on behalf of all the members. They were suing the province for mismanagement of the trust monies. That matter, this judgment that I've cited here is actually or this case rather, is, okay, I'll hurry, 5 minutes, I'm not even there yet. This action, dismissed on procedural points. The Crown argued, as part of its decision, but this was not the ultimate, this wasn't the deciding factor, but one of the arguments that had been raised by the Crown was that the MAA did not represent the settlement. So the settlement councils were aware that that was going to be an argument at some point. I'm going to skip ahead here. They brought the action again in 1977, this time in the name of one of the settlements associations. This is a very significant point, that action originally, when it was first started, it was started on the basis of just claiming mismanagement. It was subsequently amended to include a claim to unextinguished Métis Aboriginal title and breach of fiduciary obligation. So during this time, the Federation, which was the federation of all the 8 Métis settlements, they were, through this period, building, if you will, their, building their efforts, I suppose, seeking the empowerment of the settlements, really is what it was all about. 1977, they had the new claim. In the 1980s, they were advocating with the province to recognize their capacity to govern themselves. So during this whole process, there's sort of 2 parallels going on. You have the statement of claim, and you also have, at this time, legislative reform going on with the province. On the federal level, at this time, we've heard talk about the First Ministers' conferences that were going on. The Federation, rather, published Métisism, which was its position on Métis Aboriginal rights. In regards to the court case in 1990, the accord was settled. It included $310 million to be paid out to the Settlements General Council over a period of 17 years, which concludes in 2007. Fee simple title was transferred to the General Council of 1.24 million hectares. Involved the commitment to provincial legislation which would facilitate local self-government, involved the stay of the legal action, and the whole deal was passed by referendum vote. In my experience, that has all the characteristics of a modern claim. All of them. This is one of the acts that was passed as part of the Accord. And I wanted to point this particular act out because it was proposed that the settlements' lands would be constitutionally protected in the Constitution of Canada. And that sounds very good, and it is very good, because that would mean that it has protection, ultimate protection. It could never be revoked by the province.